The International Court of Justice has rejected Kyiv's request for an emergency ruling ordering Russia to stop backing separatists in eastern Ukraine. The court in The Hague said Ukraine did not provide enough evidence of Russia's alleged role in the conflict, now in its fourth year. However, the judges ordered Russia to stop discriminating against ethnic Tatars in Crimea, the peninsula Russia annexed 3 years ago.
The power of the Court to indicate provisional measures under Article 41 of the Statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. In the present case, the acts to which Ukraine refers have given rise to the death and injury of a large number of civilians. However, in order to determine whether the rights for which Ukraine seeks protection are at least plausible, it is necessary to ascertain whether there are sufficient reasons for considering that the other elements set out in Article 2, such as the elements of intention or knowledge and the element of purpose, are present. At this stage of the proceedings, Ukraine has not put before the Court evidence which affords a sufficient basis to find it plausible that these elements are present. Therefore, the Court concludes that the conditions required for the indication of provisional measures in respect of the rights alleged by Ukraine on the basis of the ICSFT are not met.
It is enough to note that neither the DSB nor the JIT appear to be concluding that civil airliner was shot down with malicious intent or, which is what matters most for today, that the equipment allegedly used was provided for that specific purpose. For the action to fall under the Montreal Convention, the intention must have been to shoot down a civilian aircraft, as military and other government aircraft are expressly excluded from the scope of this convention. For the ICSFT to apply, there must have been financing with the intent or knowledge that the funds allegedly provided be used for an act of terrorism against civilians.
Now, Russia has very serious reservations as to the reliability of the evidence that the JIT has been relying on. But if account is to be taken of that evidence, it points categorically to the absence of any knowledge or intent to finance the intentional destruction of a civilian aircraft. There is then a separate requirement of specific intent. So far as concerns Ukraine's allegations with respect to flight MH17, Article 21A incorporates the offences under the Montreal Convention, which comprise the unlawful and intentional destruction of a civilian aircraft. As to the factual situation, according to the OHCHR report on accountability for killings in Ukraine from January 2014 to May 2016, the vast majority of civilian casualties recorded on the territories controlled by the government of Ukraine and on those controlled by armed groups were caused by the indiscriminate shelling of residential areas in violation of the IHL principle of distinction. And that is an important overview of a period in excess of 2 years that covers all the major acts on which Ukraine relies. According to the OHCHR, civilian casualties caused by indiscriminate shelling on areas controlled by both sides, not terrorism.
The most glaring example of the court's negligence, if you wish, in the similar cases was in 1993 when the International Court of Justice, when Bosnia and Herzegovina was asking the International Court of Justice to order Serbia and Montenegro to refrain from similar activities which Ukraine is now asking the court to do, and not to prevent crimes against humanity and crimes of genocide. And we all know very well that even the court did request and did rule in favor of Bosnia and Herzegovina in that matter. Just in 2 years' time, the grave massacre in Srebrenica took place. So this court's order was in no much help, did not do much help to Bosnia and Herzegovina.